So Alan Dershowitz said that Trump's impeachment trial that is currently going before the Senate for trial is a motion to dismiss trial, save for political reasons. Now, I don't mean to disagree with a world-renowned constitutional scholar, but... Viva Frei Montreal litigator turned YouTuber, and Donald Trump's impeachment trial starts before the Senate today. The entire process is enough to give even trained attorneys a headache. It is procedurally complicated. The questions at law are tremendously complex to the point where there is disagreement even among the world's top constitutional scholars. And at the end of the day, it is also fundamentally political. So above and beyond all the questions of procedure and law, there are all the emotions and passions that go into all issues political. So where do we start? Well, on the first day of the trial before the Senate is going to approve of the rules to be applied throughout the impeachment trial. Now, these are procedural and not substantive rules that need to be approved by a majority of the Senate. And while the rules are technically negotiated between the Senate Majority Leader Mitch McConnell and the Senate Minority Leader Chuck Schumer, they require only a simple majority to pass, meaning 51 of the 100 senators. And to the extent that Republicans control the Senate, you know pretty much with relative certainty that once Mitch McConnell proposes the rules, they are going to pass with the required 51 votes. And to the extent that this is also fundamentally political, you know with relative certainty that Chuck Schumer and the Democrats are going to complain about the rules as adopted. It's pretty much par for the course with any political process. The rules get passed by the majority, the minority complains that the rules as passed are fundamentally unfair, and so it goes. So today the Senate is going to vote on the rules as proposed by Mitch McConnell, and you know sure as sugar, Chuck Schumer is going to have amendments to propose afterwards. And those amendments to the rules are going to be subject to the same simple majority vote in order to pass. And the resolution that is expected to pass reads as follows, or at least the essential parts. Resolved that the House of Representatives shall file its record with the Secretary of the Senate, which will consist of those publicly available materials that have been submitted to or produced by the House Judiciary Committee, including transcripts of public hearings or markups and any materials printed by the House of Representatives or the House Judiciary Committee pursuant to House Resolution 660. Materials in this record may be admitted into evidence by motion made after the Senate has disposed of the question of whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. The President and the House of Representatives shall have until 9 a.m. on Wednesday, January 22nd, 2020 to file any motions permitted under the rules of impeachment with the exception of motions to subpoena witnesses or documents, or any other evidentiary motions. Responses to any such motions shall be filed no later than 11 a.m. on Wednesday, January 22nd, 2020. Arguments on such motions shall begin at 1 p.m. on Wednesday, January 22nd, 2020, and each side may determine the number of persons to make its representations, following which the Senate shall deliberate, if so ordered under the impeachment rules, and vote on any such motions. Following the disposition of such motions, or if no motions are made, then the House of Representatives shall make its presentation in support of the articles of impeachment for a period of time not to exceed 24 hours over up to 2 session days. Following the House of Representatives presentation, the President shall make his presentation for a period not to exceed 24 hours over up to 2 session days. Upon the conclusion of the President's presentation, senators may question the parties for a period of time not to exceed 16 hours. Upon the conclusion of questions by the Senate, there shall be 4 hours of arguments by the parties equally divided, followed by deliberation by the Senate, if so ordered under the impeachment rules, on the question of whether it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. The Senate, without any intervening action, motion, or amendment, shall then decide by the yeas and nays whether it shall be in order to consider and debate under the impeachment rules. Following the disposition of that question, other motions provided under the impeachment rules shall be in order. If the Senate agrees to allow either the House of Representatives or the President to subpoena witnesses, the witnesses shall first be deposed, and the Senate shall decide after depositions which witnesses shall testify. No testimony shall be admissible in the Senate unless the parties have had an opportunity to depose such witnesses. At the conclusion of the deliberations by the Senate shall vote on each article of impeachment. So that is the resolution that is expected to pass the Senate by vote today. And as predicted, Chuck Schumer, for and on behalf of the Democrats, has taken issue with the proposed resolution. One aspect of Schumer's complaint is that this resolution as drafted makes it very difficult or unclear how additional witness testimony might be admitted into the trial. The other aspect of the complaint is that by condensing the arguments into 24-hour periods over 2 sessions, there's going to be testimony in the middle of the night so that people are not necessarily going to see what's going on. Appreciate how you will Chuck Schumer's objections to the rules as proposed, but those are his objections. Now, I did a vlog where I walked through and explained the actual articles of impeachment themselves. If you haven't seen that video, I'm going to link it right here. Give it a watch before moving on with this one so that you know what the articles of impeachment say. On Monday, President Trump's team filed their argument response brief to the articles of impeachment. It is a very lengthy document, 171 pages with argument and exhibits. And I was going to do a video explaining it, but it is just simply an impossible task to do. It's an impossible impossible task on the one hand, and it's somewhat redundant on the other because it does nothing more than elaborate in great detail the arguments that have already been raised as of the present date. For the purposes of this vlog, and before getting into Alan Dershowitz's comments on the appropriateness of a motion to dismiss, I'm just going to summarize or highlight some of the key arguments raised in that argument brief. Executive summary. The articles of impeachment now before the Senate are an affront to the Constitution and to our democratic institutions. The articles themselves and the rigged process that brought them here are a brazenly political act by House Democrats that must be rejected. They debase the grave power of impeachment and disdain the solemn responsibility that power entails. Anyone having the most basic respect for the sovereign will of the American people would shudder at the enormity of casting a vote to impeach a duly elected president. By contrast, upon tallying their votes, the House Democrats jeered until they were scolded into silence by the Speaker. The process that brought the articles here violated every precedent and every principle of fairness followed in impeachment inquiries for more than 150 years. Even so, all that House Democrats have succeeded in proving is that the president did absolutely nothing wrong. After focus group testing various charges for weeks, House Democrats settled on 2 flimsy articles of impeachment that allege no crime or violation of law whatsoever, much less high crimes and misdemeanors as required by the Constitution. They do not remotely approach the constitutional threshold for removing a president from office. The diluted standard asserted here would permanently weaken the presidency and forever alter the balance among the branches of government in a manner that offends the constitutional design established by the founders. House Democrats jettisoned all precedent and principle because their impeachment inquisition was never really about discovering the truth or conducting a fair investigation. Instead, House Democrats were determined from the outset to find some way, any way, to corrupt the extraordinary power of impeachment for use as a political tool to overturn the result of the 2016 election and to interfere in the 2020 election. All of this is a dangerous perversion of the Constitution that the Senate should swiftly and roundly condemn. Alright, so bearing in mind that this is the executive summary of the argument brief in support of the president's position, one would expect nothing less from an executive summary. It is pure argument in support of the president's position. That is the purpose of the argument brief. As far as the substance of the argument brief goes, here are some of the top line points. The articles fail because they do not identify any impeachable offense. House Democrats' novel theory of abuse of power improperly supplants the standard of high crimes and misdemeanors with a made-up theory that would permanently weaken the presidency by effectively permitting impeachments based merely on policy disagreements. By limiting impeachment to cases of, quote, treason, bribery, or other high crimes and misdemeanors, the framers restricted impeachment to specific offenses against already known and established law. That was a deliberate choice designed to constrain the impeachment power. In keeping with that restriction, every prior presidential impeachment in our history has been based on alleged violations of existing law, indeed criminal law. Does the impeachable offense need to be an actual crime? Now, while there is some disagreement on the question, it seems that most constitutional scholars agree that an impeachable offense need not be an actual criminal act. So this is going to be one of the core constitutional questions at issue. Defending the separation of powers is not an impeachable offense. Contrary to House Democrats' claims, asserting legal rights and constitutional privileges of the executive branch is not obstruction. The impeachment inquiry in the House was irredeemably flawed. House Democrats' inquiry violated all precedent and due process. The process that resulted in these articles of impeachment was flawed from the start. Since the founding of the Republic, the House has never launched an impeachment inquiry against the president without a vote of the full House authorizing it. And there is good reason for that. No committee can investigate pursuant to powers assigned by the Constitution to the House, including the, quote, sole power of impeachment, unless the House has voted to delegate authority to the committee. Here, it was emblematic of the lack of seriousness that characterized this whole process that House Democrats cast law and history aside and started their purported inquiry with nothing more than a press conference. And as far as the irredeemably flawed due process goes, I'm going to mention it here because I feel a lot of you are thinking about it, that the Republicans are still waiting on their minority day hearing that Nadler had promised them in the impeachment inquiry hearing. In one of my previous vlogs, when I pointed out what was going on at that time in the impeachment inquiry hearings, a lot of comments were to the effect of, hey, when are they getting that minority day hearing? And lo and behold, they never got that minority day hearing. The minority day hearing being the hearing where the minority Republicans could call their own witnesses to testify. Article 1 fails because House Democrats have no evidence to support their claims. That is going to be for the Senate to determine on the merits, but we would expect nothing less in the president's argument brief. The articles are structurally deficient and can only result in acquittal. This is an interesting one. The articles are also defective because each charges multiple different acts as possible grounds for conviction. The problem with offering such a menu of options is that for a valid conviction, the Constitution requires 2/3 of senators present to agree on the specific basis for conviction. A vote on these articles, however, cannot ensure that a 2/3 majority agreed on a particular ground for conviction. Instead, such a vote could reflect an amalgamation of votes resting on several different theories, no single one of which would have garnered 2/3 support if it had been presented separately. This structural deficiency cannot be remedied by dividing the different allegations within each article for voting, because that is prohibited under Senate rules. The only constitutional option is for the Senate to reject the articles as framed and acquit the president. Now, this is a very interesting argument, and going through the vlog where I walked through the articles of impeachment themselves, you can sort of see what they're getting at. Allegations of multiple acts, any one of which might culminate in the alleged abuse of power. This argument is obviously less applicable to the obstruction charge because with respect to the obstruction charge, we know what acts are in question. But with respect to the impeachment charge of abuse of power, what we do see is allegations to a slew of conduct, any one of which or all of which could culminate in an accusation of abuse of power. And so what the president is arguing in his brief is that this is not a case where you can just throw everything against the wall and hope something sticks. This is a case where we need to know exactly what was thrown against the wall. Was it spaghetti? Was it linguine? Was it ziti? We need to know what pasta was thrown against the wall. Again, it's an argument. It's an interesting one. Make what you will of it. The articles fail to state impeachable offenses as a matter of law. House Democrats' novel theory of, quote, abuse of power does not state an impeachable offense and would do lasting damage to the separation of powers. House Democrats' novel conception of abuse of power as a supposedly impeachable offense is constitutionally defective. It supplants the framers' standards of, quote, high crimes and misdemeanors with a made-up theory that the president can be impeached and removed from office under an amorphous and undefined standard of abuse of power. The framers adopted a standard that requires a violation of established law to state an impeachable offense. By contrast, in their articles of impeachment, House Democrats have not even attempted to identify any law that was violated. And now we're getting back to that original question as to whether or not an impeachable offense has to be a criminal act. And subsidiarily, to the extent that we come to the conclusion that an impeachable offense need not be an actual criminal act, we're getting into the more broad interpretation as to whether or not alleged abuse of power qualifies as a high crime and misdemeanor under the Constitution. House Democrats' charge of obstruction fails because invoking constitutionally based privileges and immunities to protect the separation of powers is not an impeachable offense. More than 200 years of precedent confirm that the House must vote to begin an impeachment inquiry. Historical practice confirms the need for a House vote to launch an impeachment inquiry. Since the founding of the Republic, the House has never undertaken the solemn responsibility of a presidential impeachment inquiry without first authorizing a particular committee to begin the inquiry. That has also been the House's nearly unbroken practice for every judicial impeachment for 200 years. And the argument is that the process itself is so fundamentally deficient and contrary to the fundamental rule of due process that the Senate should just dismiss the charges outright. Again, make what you will of the argument. At the very least, now you know the argument. The subpoenas issued before House Resolution 660 were invalid and remain invalid because the resolution did not ratify them. Again, a purely procedural argument, but a procedural argument that taints the entire process, according to the president. Asserting legal defenses and privileges is not obstruction. And this is something that I've mentioned in previous vlogs. Executive privilege is just that. It's executive privilege to not comply with certain requests made by the House. And this was, at the very least up until this impeachment inquiry, a bipartisan accepted state of facts. The spin that is being put on it now is that while the president can lawfully exercise executive privilege in other contexts, the president cannot exercise executive privilege in the context of an impeachment inquiry. To do so would effectively deprive the House of their sole power of impeachment, and to do so would qualify as obstruction and itself be an impeachable offense. That's the argument. The text and structure of the Constitution demand that the House ensure fundamentally fair procedures in an impeachment inquiry. The Federal Due Process Clause broadly states that no person shall be deprived of life, liberty, or property without due process of law, and applies to every part of the federal government. In any proceeding that may lead to a deprivation of a protected interest, it requires fair procedures commensurate with the interests at stake. There is no exemption from the clause for Congress. Thus, for example, the Supreme Court has held that due process protections apply to congressional investigations and provide witnesses in such investigations certain rights. Congress's power to investigate, broad as it may be, is also subject to recognized limitations, including those found in the specific individual guarantees of the Bill of Rights. It would be anomalous if the Due Process Clause applied to investigations conducted under Congress's legislative power, which aim merely to gather information for legislation, but somehow did not apply to impeachment investigations aimed at stripping individuals of their government positions. And for those of you that are wondering what anomalous means, hey Siri, what does anomalous mean?
Anomalous means deviating from what is standard, normal, or expected.
What she said.
And the rest of the brief is really an argument on the merits. The July 25 call transcript shows the president did nothing wrong. President Zelensky and other senior Ukrainian officials did not even know that the security assistance had been paused. President Trump's record of support for Ukraine is beyond reproach. Pauses on foreign aid are often necessary and appropriate. No witnesses with direct knowledge testified that President Trump conditioned a presidential meeting on investigations. And interesting drafting of this particular allegation. That necessarily implies that certain witnesses did in fact testify to that effect, but in fact lacked the first-hand knowledge to support their testimony. At least that is what one should deduce from the drafting of that allegation. It was entirely appropriate for President Trump to ask about possible Ukrainian interference in the 2016 election. And lastly, the conclusion of the argument brief. The articles of impeachment presented by House Democrats are constitutionally deficient on their face. The theories underpinning them would do lasting damage to the separation of powers under the Constitution and to our structure of government. The articles are also the product of an unprecedented and unconstitutional process that denied the president every basic right guaranteed by the Due Process Clause and fundamental principles of fairness. These articles reflect nothing more than the persecution of an intemperate or designing majority in the House of Representatives that the framers warned against. The Senate should reject the articles of impeachment and acquit the president immediately. So that is an overview of the 171-page argument brief that President Trump submitted to the Senate Monday. Now let's bring this all back to what Alan Dershowitz said of this being an appropriate opportunity for a motion to dismiss. Now we have talked at length about motions to dismiss in previous vlogs. We had the Jussie Smollett motion to dismiss, we had the Washington Post motion to dismiss, and we had the Elizabeth Warren motion to dismiss. In those particular cases, we were dealing with a Rule 12b-6 of the Federal Rules of Civil Procedure, which is a dismissal for failure to state a claim in law. Now, any motion to dismiss of the articles of impeachment before the Senate is not going to be based on a Rule 12b-6, but it is probably going to follow a very similar reasoning. And as I've discussed in previous vlogs, you have two bases for a motion to dismiss. On the one hand, you have a motion to dismiss taking for granted all of the facts alleged in the lawsuit. And in those situations, you take for granted all of the facts alleged in the lawsuit. That is to say, you say, okay, everything you've alleged, let's take for granted that it is true. You still have no claim in law. A concrete example of that would be, okay, you've alleged that 10 years ago I punched you in the face and you are now suing me civilly for damages, but the statute of limitations for a civil lawsuit for bodily harm is 3 years. So even if you assume every allegation is true, yes, 10 years ago I punched you in the face and broke your nose, you had 3 years to file that claim and you are past that period now. So even assuming the facts to be true, your claim is ill-founded in law. The other type of motion to dismiss you can have is based on the patent frivolity of the lawsuit after depositions or after some evidence has been adduced. Taking a ridiculously oversimplified example, someone sues someone for damages because they punched them in the face 1 year ago. Taking those allegations for granted, B cannot seek the dismissal of A's lawsuit. But hypothetically, in deposition, Mr. B gets Mr. A to admit that at the time he says Mr. B punched him in the face, Mr. A was actually out of the country on an all-inclusive vacation, and Mr. B was at home half a world away. Well, in this hypothetical situation, Mr. B could put forward a motion to dismiss on the basis of the patent frivolity of the lawsuit given A's admission in examination. And presenting these types of motions to dismiss typically are par for the course because you've got nothing to lose by presenting them. The worst thing that happens on a motion to dismiss, even assuming the allegations are true, is that a judge says, no, we can't dismiss this lawsuit now, go to trial. In which case, come trial time, you get a second kick at the can after you go through the actual evidence. And the same holds true of a motion to dismiss based on the patent frivolity of the lawsuit. Typically, the worst thing that's going to happen, a judge is going to say, no, I can't come to the conclusion that this lawsuit is patently frivolous at this stage. Get to a trial on the merits, adduce all of your evidence, and the judge on the merits will come to a determination of the lawsuit on the merits. And now that we've gone through the president's argument brief, we can see how the argument brief sort of positions for a motion to dismiss on both of these bases. On the one hand, the argument brief says that even if we take the allegations in the articles of impeachment for granted, they do not state any impeachable offense. The other basis of a motion to dismiss could be that the procedure itself, not the allegations, but rather what was done in the context of that impeachment inquiry, was so fundamentally unjust that we should just dismiss the lawsuit now. We're not taking the allegations for granted, we are just referring to the procedure afterwards and the fundamental injustices committed in that procedure. And if the Senate does not dismiss the articles of impeachment on these two bases, then we have our hearing on the merits, we have our trial, and the Senate votes on the substance of the issues. So that would be the basis of a motion to dismiss, and Alan Dershowitz thinks that this is a prime example where such a motion to dismiss would be warranted, but for political reasons. Obstruction of Congress is not an impeachable offense. Abuse of power is not an impeachable offense. A motion to dismiss and a perfect world would be ideal, but do the American public want to see an end to the trial so quickly? I think that becomes a political issue. And this is where I disagree to some extent with Alan Dershowitz, fully recognizing that he is by far more knowledgeable and more competent in this particular field. That being said, I'm not relying on my own opinion, I'm relying on the opinion of scholars who are not so clear-cut on whether or not non-criminal acts can serve as the basis for an impeachment. So when Dershowitz says obstruction of Congress is not an impeachable offense, abuse of power is not an impeachable offense, he is arguing from conclusions and not towards them. Whether or not obstruction of Congress or abuse of power are impeachable offenses is at the very least a disputed fact. And according to a great many scholars, it wouldn't even be a disputed fact, non-criminal conduct could nonetheless serve as an impeachable offense. That being said, we agree on the political front, dismissing the case summarily would be disastrous. Nobody would think that the process is fair, and while people are still not going to think that the process was fair regardless of the outcome, at the very least they will have had their day in court. Get to a hearing on the merits, get to a vote on the merits, and eliminate what you know would otherwise be an argument by Democrats to the effect that this was a political dismissal of suit before the evidence could even be adduced. And the flip side, there are a lot of people hypothesizing that the Republicans would be better off not to dismiss it at an early stage even if they could. Get to a hearing on the merits, have the Republicans adduce evidence that they want the American public to see, then vote on the merits. And by all accounts, the outcome is pretty much a foregone conclusion, and while it still holds true that you never really know the outcome with certainty when you leave it in the hands of a judge, in this particular case, if you're confident that you would otherwise succeed on a summary motion to dismiss, you can be relatively confident that you will win on the merits. Trump can always raise the same arguments after all the evidence has been adduced, adduced. The claim is ill-founded even taking the allegations for granted. The claim is frivolous given the absence of evidence. And notwithstanding those two arguments, they have simply failed to make their case for impeachment. So that is the overview, breakdown, assessment, predictions as of today. And if you like this video, please be sure to like, share, subscribe, hit the notification bell, drop a comment in the comment section below because that helps feed the algorithm. If you want to support the channel, I've got merch links in the pinned comment. There is a PayPal link in case anybody feels more comfortable supporting the channel that way. If anybody wants to refresh their memory on what is a motion to dismiss, I'm going to link one of those videos right here. Give it a watch. And now you know your vlog. Peace out. Booyah!